My next question, I'd like to start with Professor Roosevelt. We know that the current Supreme Court jurisprudence on the death penalty continues to uphold its constitutionality. How about the constitutionality of a federal law prohibiting the use of the death penalty as a form of punishment by the federal courts or the courts of any state? How would your ideal justice vote on that law?
Well, as far as the federal courts go, I think that's a pretty easy question. My ideal justice would say if Congress wants to say there shall be no federal crimes punishable by the death penalty, Congress can say that. Now, as far as the states are concerned, it's a much harder question. The question would be, where does the federal government get the power to do that? Where does the federal government get the power to say the states are limited in the kinds of punishments that they might inflict? And I think the best argument would be that Congress is using its powers to enforce the 14th Amendment. You could say Congress is enforcing the cruel and unusual punishment clause. But you would have this problem, of course, that the Supreme Court has said, and I think this is right, my ideal justice would agree with it, the death penalty, if the states choose it, is constitutional. So it's hard to see how Congress would be enforcing the cruel and unusual punishment clause if they pass a law forbidding something that that clause actually permits. So is there any other constitutional provision Congress might be legislating under? Well, you could make an argument, and I think this would probably be the most promising way to go, that Congress is enforcing the Equal Protection Clause, and Congress is concerned about racial disparities in sentencing, and Congress has looked at the data, and there's a lot of statistical studies on this actually, and Congress has noticed that you get the death penalty much more for killing a white person than for killing a black person. It turns out the race of the offender is also slightly significant. Blacks are more likely to receive the death penalty than whites, but actually the big difference is it depends on who you kill. And if Congress mustered a strong enough showing, if Congress could make a very good demonstration that there's a serious problem with racial inequities in administration of the death penalty, my justice might uphold that. I think that it's unlikely that Congress could make a good enough showing. Once again, this would be a narrow decision. This would be fact-specific. This would depend on the strength of the factual record that Congress could generate. My guess is, though, that my ideal justice would say this goes beyond Congress's powers. This can't be enforced against the states.
Thank you. Mr. Levey, the same question. How would your ideal justice vote on that?
Well, my ideal justice largely agrees with Professor Roosevelt. Certainly, Congress could do it with regard to federal law. The only way I can really think of to do it with regard to state law would be the Eighth Amendment, cruel and unusual punishment, but for exactly the reasons Professor Roosevelt said, I think that would be a stretch. I think that certainly we know that under current doctrine, it's not enough under the 14th Amendment just to show some sort of lack of proportionality, that, for example, more African Americans, a higher percentage of African Americans get the death penalty, or a higher percentage of murderers of whites get the death penalty. I mean, just to show you why that would obviously, that's not proof of discrimination. 99%, if not more, of the people who get the death penalty are men. But is that sex discrimination? I don't think that that's much evidence of sex discrimination. So just to say there's a disparity. So again, I think I have to agree with Professor Roosevelt that while if Congress could make a showing that there was pernicious discrimination here, then it would come under the 14th Amendment Equal Protection Clause, but I just don't think Congress could make that showing.
Thank you.